I'm looking forward to us being back together in person. I apologize for the mess behind me. I've taken up the hobby of refurbishing vintage stereo equipment, so there's all kinds of fun stuff on the table behind me. And I want to thank Tim Holbrook. He helped to locate some folks and the panelists tonight, and some other folks who volunteered, and we just did not end up needing their services. Um, I'm going to introduce the panelists, and I'm going to give a real brief, deliberately high level overview of the appellate process at the Federal Circuit. And then we have a series of questions that came from members of the Inn, and then we'll just let everybody talk about their experiences and their insights. And if you have additional questions, please put them in the chat, and I'll try to pop them in when they make some sense. We have Nora Shu, who clerked for Judge Chen at the Federal Circuit from 2019 to 2020. She's now a senior associate at Wilmer Hale in Washington, D.C., where she practices IP litigation in district courts, the Federal Circuit, and at the PTAB. She also has an active pro bono practice in which she represents veterans and disability benefits appeals and discharge upgrade reviews. That's one of the things, by the way, the Federal Circuit has jurisdiction over, and I'll talk a little tiny bit about that. Nick Murray, he clerked for Judge Stoll at the Federal Circuit from March 2020 to September 2021. Before clerking, he worked at Alston and Bird for about a year and a half in Charlotte, and then he returned there as an associate. He also does IP litigation, mostly handling cases in district courts, the ITC, the PTAB, and also at the Federal Circuit. And then two people who are a little bit more familiar to y'all. We've got Kelly Mullally, who's served as a law clerk for Judge Edmondson at the 11th Circuit, and also Judge Bryson on the Federal Circuit before she joined a large Atlanta IP firm where she worked on Federal Circuit appeals for several years. She then decided to earn an honest living as an academic and did a decade doing that, teaching patent law and other IP courses before she returned, and now is at the IP litigation group at Taylor English, where she does appeals on a broad range of issues, aviation disputes, tax controversies, all around the country. She's also a founding member of this Inn. Chad, I think it's Panel. Is that how it's pronounced? Um, Chad Pennell. He's practiced law for 18 years. He was a clerk also, like Kelly, at both the 11th Circuit for Judge Birch and also for Judge Gallarza at the Federal Circuit from 2005 to 2006 before he came back to practice litigation here in Atlanta, or there in Atlanta. He's one of the founding members of the Inn. He's a former president of the Inn, and he practices law with another former Federal Circuit clerk, Meredith Addy, doing in an IP litigation boutique firm, mostly doing Federal Circuit appeals, district court litigation, and also PTAB proceedings. And finally, me, and I mostly stay out of the way. As you all know, I worked at Baker Botts for a long time, came to Mercer, clerked for Rader in 2012, was at Taylor English for a little while, and since then I've been doing solo stuff and expert witnessing. I did become a certified mediator during the pandemic, so that was a good thing. So I'm going to give a real brief, high-level overview um, of appellate practice at the Federal Circuit. And again, deliberately high level because a lot of the details are things that I think other folks can give great insight into. You know, typically what happens is once the three briefs are filed, the three main briefs are filed in an appeal, the clerk has a system to run for conflicts that the judge might face. And then what happens is every month there's a random computer generated list of three judges that'll serve on each panel. And, you know, getting through the conflict system and using that random system, the cases are assigned to a particular panel. The briefs arrive in the chambers. The clerks sit down and look through them and divide them up according to expertise, workload, interests, you know, you name it, whatever is going on within the particular chambers. And one of the things, you know, there is a wide range of jurisdiction that the Federal Circuit has. They do tax cases. I remember doing a takings case, patent cases, veterans appeals, and lots of other issues just happen to come up in the cases besides patent law. But obviously, patent law is why most of you are here. What happens then is it varies by chamber, and I'm sure we'll hear a bit about that. But the clerks, you know, form a process, do a process where they sit down and discuss the case with the judge. Usually, at least in Judge Rader's chambers, we would roundtable it. A clerk would present based on a memo the judge had read. everybody would question, challenge, and try to figure out what the right answer was to the particular appeal. Then what happens is oral argument. It's 15 minutes per side. It goes very, very quickly at the federal circuit. During that, the clerks are connected, or a lot of the clerks were connected, and I assume still are connected by laptop to their.
So these manuals are en route.
And so
I got a text from Tiffany's daughter-in-law.
So Wab can, somebody, I think it's Bob who's talking through.
So,
Yep, Wab, if you'll please mute your.
this, of course.
So what happens is
I don't
that
think
the
there's
clerk,
a lot on with her. Don't.
the clerk can go in.
Hey, David,
Yeah.
maybe hang on just a moment. If Wab, can you mute, please? If he doesn't, then I'm going to put him in the waiting room. I have the power.
Ooh.
I'll text Wab and tell him to put himself on mute.
There he
Oh,
is.
there he goes.
So the clerks are connected by laptop, and so can write questions to the judge during oral argument. If somebody says the record says such and such and it doesn't, the clerk can point that out to the judge rather quickly. What happens afterwards is the judges usually go back immediately and have a conference. They vote in reverse seniority order. So the youngest or newest judge goes first and votes, and that leaves to the most senior judge on that panel the deciding vote if there is a split. They then come back to chambers and, they tell you what happened. So either it's going to be a Rule 36 affirmance, which I hated as a lawyer, but which I loved as a clerk, or there's going to be an opinion either affirming or reversing what happened in the district court. And someone will have been assigned or volunteered to take the role of writing that opinion. Process of opinion writing then takes place. It's circulating among the panel, and then it gets issued, and somebody is happy and somebody is sad. That, in a very high level, is what happens in an appeal at the federal circuit. So with that, I wanted to start off, and again, if you have specific questions, post them in the chat room, and I'll ask them as we go along. But what roles, Kelly? I'll throw this one to you first, but everybody, again, feel free to chime in. I described what I saw in Raiders chambers back then, but what role did you see clerks play at the court?
Well, very broadly speaking, the role is to support the judge in resolving disputes that come before the court. And the majority of those come up through the merits appeal process that David just did a great job explaining. There's also motions practice where the law clerks get involved. I'll say that's something that's pretty unusual about the federal circuit and involving their law clerks that I really enjoyed and appreciate more even now that I'm in practice again, because you see some of the complex procedural issues that come before the court. And some of those are pre-panel before you are even thinking about oral arguments, because there are certain issues that arise when litigants seek certain relief that occur very early in the stage of a case, or if a party is seeking an interlocutory appeal, so there's not even a notice of appeal. And so you get to participate in that process when your judge is the motions judge, or if it somehow gets assigned to a panel of judges that have to resolve that. And so being a part of that is also a really interesting role that the clerks play. You learn a lot that way. In my judges' chambers, it was a lot like David described in Judge Rader's chambers, where we talked about the cases. There was one clerk who was primarily responsible for a particular appeal, but Judge Bryson was much more focused on discussing the cases than some other judges who really want a bench memo for every case. We would do that for really significant cases like in bank cases. My year, David was talking about Alice. My year was Festo. And so there would be a lot more that would happen in terms of written work product before the argument. Beyond that, just adding to what David said, some things people may not realize that the clerks do as a case is getting teed up for oral argument would be looking at physical evidence. If there has been any submitted, it's rare, but it does happen. If there's a physical commercial embodiment of see patented technology that's been provided to the court. If it's helpful to the judges, the clerks might go and inspect that and observe it. And then just generally the process of opinion writing is very time consuming, very rewarding. You learn a lot doing it. And so there's a lot of research and writing that goes on in that process.
What about the rest of our esteemed panel? What did you experience differently, see differently? How common were bench memos as opposed to discussions?
I think, in our chambers, I think most of the chambers, I'd be interested. I know our younger panelists have probably more recent experience with some of the more recent judges, but I clerked in both the 11th Circuit and Federal Circuit, and I know a lot of the chambers practices when I was there at the Federal Circuit. Most of the time, the Federal Circuit clerks would divide up, each case, and you would write a bench memo of some sort or some sort of summary for the judge to take a look at. I think in our case, a lot of times the judge would read through the briefs. He would have you write a bench memo and you would turn in your bench memo, and he would kind of have an idea without reading your bench memo of what he thought the outcome should be. And then to read your bench memo to see if you had sort of the same conclusions that he did. And then we would gather the week before oral argument. Oral argument of the Federal Circuit is always the first full week of the month. So the week before, we would usually gather all the clerks, which was unusual in our chambers. It'd be all the clerks and the judge, and the other clerks were supposed to read your bench memo, and you would basically they would murder board us, or we would murder board each other, the judge and the other clerks, and we would present the way we thought it should come out. And the other clerks would kind of ask us questions, and kind of like you're at oral argument, for whatever side, which was kind of interesting. But I'd love to hear from the newer clerks, see if there's anybody different on some of that.
I think that's pretty similar to what we did in Judge Chen's chambers. I think something my judge did, at least, which was a little bit different, was he would ask us like a zillion questions about each case. So we would give him a pretty long bench memo, and then he would just send us like a series of a zillion questions. And through that process, that would help both of us understand the issues very well. And then we would have a series of conversations with him also before the oral argument.
Nick, what about you?
Sure. So Judge Stoll, I think, was very similar, maybe a bit of a hybrid. We did have formal bench memos. Generally, they'd be staggered. Your deadlines would be staggered. It was very common to have conversations with Judge Stoll during your process of writing and researching, making sure you're running down the right rabbit holes. But then we did also generally do sort of the oral argument type thing where we all gathered together and ask questions. And we would do that sort of each week or every other week at least. So we didn't have them all on one day. Very similar, ultimately.
What about, someone asked a question about interaction between or among clerks from different chambers before oral argument. I honestly don't remember well enough. I remember afterwards, during opinion drafting, but I don't remember before. What was your experience with that? So before oral argument, talking to clerks from other chambers to get the pulse of other chambers.
Yeah, so that was a lot more common than I anticipated. And when I say common, I think I did it probably for every case that was argued. Perhaps there are a couple that didn't, maybe some. I wouldn't say a formal process, but generally we would all get together and talk. It was mostly just us talking, us working through the issues, discussing anything that was tough. Oftentimes it would be a little earlier on, so you maybe haven't come to a final conclusion just yet. But so it's really more of a clerk discussion, and so the clerks can sort of work through it together. Maybe before you've talked to your judge. You may have talked to your judge at that point, but it just depended. But it was very common ultimately.
Is that your experience too, Nora? I honestly don't remember.
Yeah, that was my experience also. And I clerked before the pandemic, or a lot of my clerkship was before the pandemic. So it was actually a great way to get to know the other clerks, just getting together in chambers and talking through the issues together. And oftentimes, if you had a conversation with your judge beforehand, you could kind of advocate for the conclusions that you had come to together. So it was a really good process to understand the issues well, and really valuable.
And someone has asked, Art asked about the draft opinions. And I remember after the panel would draft it, it would go on, if I recall right, it was called 10-day, but it really wasn't 10-day. It was like 5-day or something. And it never made any sense to me. But can one of you explain the process that you saw when a panel would, once the panel arrived at the opinion that they had, which was obviously perhaps a back and forth among the judges and the clerks, it goes on distribution to the court as a whole. And is it 10-day? Am I remembering the term right?
I think it's changed over the years. I mean, I think now it may be 10-day. I know when we were doing it, I think it was 8-day or something like that. But yeah, for precedential opinions, not the Rule 36, not the non-precedential panel opinions, but for any of the precedential opinions, it would go out to the entire court, and the court had a chance to read it and even make comments if they felt that there was something wrong. Or very rarely did we ever get comments back that I recall. I think that changed a little bit because they added more clerks to each judge's staff, and I think people had more time to review stuff and come up with some additional comments. But every now and then it was helpful, just because you had a lot of judges had sort of different issues that were kind of, I shouldn't say they're pet issues, but some they were highly focused on. And so if your wording just kind of screwed up a rule, or could be viewed as screwing up a rule, they may kind of come back and say, I think this takes the law in a way that we don't, in a direction we don't want to go. Now, I mean, they can't necessarily change what the panel does, but they can, usually the panel and the judges would take it under advisement and make any edits. But I can only remember that out of probably the 40 or 50 cases that I had, I can only remember ever getting comments back once or twice from another judge.
Nora and Nick, what about you guys?
I think that's right, that they're more common these days to get comments back from I think it was the 10-day. I think maybe back in the day it would have been 8 or 7, but I know that date has changed. But I think it was a few years ago that by statute, the federal appellate judges get 4 clerks rather than 3 now. And so they just have more bandwidth to work through the precedential opinions now. So there are certain judges which they'll read every precedential opinion that comes through and have a clerk give comments about them. So I think it was pretty common to get comments back for every precedential decision that we would write as a chambers.
Yeah, and I'll add, and this goes back a little to the question we first asked on the role of clerks in chambers. Something I didn't appreciate was, besides obviously supporting the judge in decisions and all that, certainly reading precedential opinions was a big part of it. Something that we spend a lot of time on, as well as reviewing petitions for rehearing and rehearing en banc that you get a lot of. All of those get reviewed. But we definitely did get comments, and I think most of the comments generally would probably be, what we called clerk to clerk nits, so more stylistic things that didn't necessarily require judges to approve, but there were probably more often than maybe Chad saw some more substantive comments.
I remember a lot of, you'd proof it and you'd see typos or little things. I do remember one time there was an opinion that the judge wrote that, it was the panel wrote, and I had a real substantive problem with a part of it. And the judge ended up writing, Chief Rader wrote a memo to the panel to try to get a substantive change done that I could not talk the clerk through. But I only recall it happening one time out of whatever it was, 100 opinions I looked at. Let me, did anybody have anything to add to that before I move on to kind of the next phase of this? So I'll jump to Art's question and then I'll jump back a little bit. The broader question, that this is for everybody, but Nora, your name is listed first on this question, so you'll get it again. What are bad briefing practices and good briefing practices? And Art's more specific question, which is part of this, is the magic number 3 for the number of issues that a wise appellant should include. And he says, obviously, if you get to 5 or 6, you're in real trouble. So share your wisdom.
That's a great question. And it's actually one of the kind of good versus bad briefing practices I was thinking of. And one of the points I was going to say is that a kitchen sink approach is generally not effective, and that appellants should really try to focus and narrow down the issues to the few that have a decent chance of winning. I think, as the clerks, we would tend to get kind of annoyed when issues were appealed that had a very little chance of winning, or when there were just a zillion issues involved that, that were not good issues to appeal. I think there are a few other probably good points I can make here. One is to write in a way that's concise, clear, and simple, using good guideposts. And that could involve really spending time on the table of contents so that someone skimming it could understand the arguments very quickly. Good headings, good topic sentences. And these are just general writing types of advice that would apply really to any brief. Another kind of writing type of point to make is that short sentences are generally easier to digest. So, just think about kind of how to give someone the guideposts to digest the issues really quickly. And then another point I think that is specific to patent cases is that when the technology is very complicated, I think the judges and the clerks appreciate when the brief explains the technology very well. So it's worth spending some time on that.
Yeah, I would probably echo the simplicity. I know Art said like 3 issues. I think 3 issues is about as much as you want to go, unless there's no other way to win but have 4 issues. Now, I would caveat that with, whenever I have a client or I have a case where there are sort of multiple issues, I try to group them around a legal question. So, for example, if you have like the district court screwed up a bunch of claim construction, but 2 or 3 of them were screwed up because it misapplied the means plus function analysis or something, or the indefiniteness analysis. You can say like, well, the court legally erred on indefiniteness for these 2 or 3 claims. And rather than having a statement of issue that has each claim term delineated, I think Judge Freeman, who has passed away, but when I was on the court, he was about 95 years old and was a senior judge. He would say, like, the first thing I look at when I open up a brief is the statement of issues. And if you have like 7 or 8 issues listed there, I'm going to think either you don't know what you're doing, or the district judge is completely incompetent if he made that many mistakes below. And he's like, I can tell you which one I'm going to think first. So, I think you have to look at most people say, list all the issues you think you can raise and take your top 3 and run with them. But, if you do have a lot of issues, try to think of ways to group them into 3 so that when you have that statement of issues, you only have 3 things there. A couple of things that Nora didn't say. I know that sometimes in the Federal Circuit, there's a lot of just sort of argument that we always saw in the briefs. I mean, there's a lot of sniping at your opposition, which I think is really bad. And it's very apparent, and it's just a court. You can kind of get away with it maybe in the district court or in a state court, but it's really hard to get away with it in front of a federal appellate court. So, yes, you need to be an advocate for your side and make your argument, but don't get too abusive to the other side. The other thing I would say as far as good and bad practices, go into the rules and there's kind of definitions of what each section of the brief has. Like you have statement of the case, you have background facts, you have summary of the argument, you have argument. The most irritating thing to me when I was reading a brief is you would have argument in the statement of the facts. And, that I think that's bad for a lot of different reasons. I think you don't get your story out in the facts, but you may say something in that and then don't repeat it later in your argument. And when I'm writing something up like a bench memo, I completely miss it. But stick with what the court wants to see in its rules. I adopt what I call the rule of three whenever I'm writing briefs, especially the Federal Circuit, which is have about 3 sentences per paragraph. Each sentence is about 3 lines long. Each page has about 3 paragraphs on it. And then each section before you get to another heading is at most 3 pages per section. Not to say that you can't go 3, 4, 5, whatever, but a judge starts to lose a lot of interest when they get to about page 30 of your brief. And I think if you have these long run-on sentences or paragraphs, it can be really problematic and tiring. I'll stop there. I'm sure somebody else has something else to add on this, but.
I think someone asked a question about common don'ts. I think a good common don't to raise is that not to stretch the record in a way that's not supported, because the clerks and the judges do look at the record, and especially the most important evidence, and can tell when an assertion isn't supported.
I'm curious for particularly for Nick, but also for Nora, because you guys were there more recently. Did you or judges or other clerks or judges read on iPads or computers more than paper? And if so, were there things that folks did in their briefs that helped or hurt in that context, not paper, but electronic writing?
We did not. We were a papers chamber. I did use my computer quite a bit. Obviously, we had access to it. I'm not sure there's anything necessarily that would differentiate the two. I use them interchangeably.
I've always read on paper just by habit, but some people do read briefs, the PDF versions, or I've never tried it, but I know that there was a way that if you clicked on a citation, it would take you straight to the JA site. So that's very useful to have. I unfortunately didn't use that, but I can see it being very useful.
And the reason I ask is I'm old, you guys are young, but I can't read if it's not on paper. I have to make marginal notes and stuff. I mean, I can read, but I can't really grasp. And I didn't know if that was something that had changed, especially with the pandemic, because I think they went to no paper for a little while, if I remember right. You couldn't file on paper. Am I misremembering that?
So I started right as the pandemic started. And I always had paper. That was my once a month trip to chambers, was to go pick up my paper briefs. But I did.
Go ahead. I'm sorry.
Have PDF copies available, and I will say, if it was an important case, I did generally make notes in the PDF copy so that I could share it with Judge Stoll. So that was useful. But
hey, we have a kind of a follow-up question. It said about Chad's sniping comment. Is it because the appellate court is detached from the dispute, not as emotionally involved as the way trial counsel can get? To me, in my experience, the Federal Circuit judges were, more detached than certainly a trial court judge, and perhaps more detached than I saw like in the Fifth Circuit when I was there, and once in the 11th Circuit. But what are your thoughts about why sniping is so bad, and why the opposite of that, being collegial, might be a more effective way?
Well, I know that Warren's judge that he clerked for gets very emotionally attached to all of his cases. I think that a lot of district judges, I would avoid sniping in front of district judges too. I think they're probably more used to it because they do handle a lot of aspects of the case over a long period of time, especially if it goes to trial. But I think that any judge that's been around for a long period of time, gets tired of and when I say sniping, it's like, they're lying or they're dishonest and just stuff that it's like, well, that doesn't really help. I think the reason the Federal Circuit sniping in kind of more of I shouldn't say personal attack, but a little bit more of an attack on the character is because appellate courts are usually more worried about the law. Like, did the lower court apply the law correctly? Is there something here in the record that I could reverse on? I think the predilection, even when you have de novo review, is to, hopefully affirm rather than having to, reverse a case. And I think when you get down into sort of these, petty attacks on the other side or what they may have done that really doesn't bear on the legal issue in front of the court or the review of the record in front of the court, it just takes away from your argument. I mean, the example that I use, and I think for anybody that's gone to sort of the Georgia IP conference where Judge Moore speaks a lot, I think she had one of the Apple Samsung cases, and I think she opened up the opening brief, and it was just so heavy handed on attacking the other side and how terrible Apple or Samsung was and how horrible an infringer they were. And she was like, well, this is terrible. And she put it down and she opened up the red brief, the appellee brief, and it was the same way. And she was like, this is awful, and I mean, I think at oral argument laid into both parties about how horrible their briefs were. And so I think when you do that, a lot of times what the court will do or a judge will do in some cases is just like, well, I'm not going to read their brief anymore. Let me see what the other brief says and see if they're a little bit nicer. And I think that's just, they don't have a lot of time with it, and they expect a level of decorum that's even higher than, the state court or a district court.
I think part of it comes from the fact that the Federal Circuit, I think, is extremely collegial. I mean, I think most courts are, but you do hear horror stories about the Ninth Circuit. And I know we had some questions about sort of how does the Federal Circuit compare to other courts? And there's so much more interaction between not just the law clerks, like we were talking about, but the judges as well, simply because they're physically located in the same building, which is not true in most other circuit courts. You're spread out over several states. The sittings, don't always line up. Some judges might not sit together very often at all. They're scheduled usually for a week together, whereas the Federal Circuit panel assignments change daily within a sitting week. And so it's the way they operate, and they expect counsel to come before them and operate the same way. I agree with everything that's been said about not using inflammatory language. And I know some of the judges have even gone so far as to say that when that happens, it's usually the person that's lodging the complaint that's the guilty party. So it absolutely can backfire on you. And it really is to be avoided at all costs. I think Judge Moore has also spoken about this, that if you go too far and are too extreme, you'll get the question from one of the judges of, well, did you file a bar complaint? Did you inform the governing body about this conduct? Was it that bad, or are you just bothering us with it?
Not a good start to your oral argument. No, I didn't. Just bothering you with it. On oral argument, and this one, Kelly, this comes first to you. There were a group of questions about oral argument, and let me ask them and then pick which one you want to answer. What's the most effective strategy for oral argument? What are bad oral argument practices? How often does oral argument affect the outcome of a case? Do you ever think you saw a case flip, from what you expected before argument to afterwards? If so, what happened? And this is probably everybody.
There's a lot of questions there. But I know that one of the other big questions was sort of horror stories, other things to avoid. So I'll try to tie this in. Bad practices in oral argument. This ties into what Nora said about having a good command of the record and being accurate in your description of the record. So you have to be extremely prepared when you go in for oral argument. You absolutely should have your case mooted beforehand if your client has the resources for it. And the last thing you want to do is stretch on anything. The record, the cases, the judges know the cases, the law clerks know the cases in the record. And one of the scariest things that I ever heard at the Federal Circuit was when counsel misstated that something was in the record, which is also a huge no-no. Don't ever try to rely on anything that's not in the record. If you don't see it on PACER, when you pull up the district court docket, it doesn't exist for purposes of your appeal, for all practical purposes. And counsel tried to represent in open court that something had been filed, and really it was very clear and became more clear that it had not been filed. And the presiding judge on the panel leaned to the front of the bench and said, "Have you notified your malpractice carrier?" So words that no one ever wants to hear, and simply because he misstated the record. Similarly, don't misstate holdings of cases. The judges know the cases. They're very invested in the case law of the court. We were talking about the circulation process back in my day. I was in the 7-day camp where the opinions were reviewed very closely. And at the time when I was at the 11th Circuit, you sometimes had to go down to the courthouse to get the slip opinions of recently issued decisions, and counsel came into an argument with this kind of recently issued decision, and he misstated the propositions that it stood for. And one of the judges said, "If that case says what you are stating it says, I'll be withholding the mandate," because a case can come out and a petition for rehearing can be sought, and a judge can sua sponte seek to take it in bank. And that was just another scary moment that everyone would want to avoid in court. So those are some don'ts. Some do's would be absolutely answer the judge's questions. Oral argument does matter. I can't say I've seen it really flip a case, but the judges are interested in the questions that they ask. They've spent time thinking about them. It helps to clarify the issues. If the judge asks a hypothetical, answer it. Don't say it's a hypothetical. Don't say those aren't our facts. The judge knows that. The judge is trying to push the boundaries of the case. You can say, here's how our case is different and why it would still come out the way you're arguing for, but don't ignore the situation that the judge has presented to you. Answer that and then explain why your client should still win.
About the rest of you, I recall Judge Dyke more than once, probably more than 100 times, asking a question and counsel not answering it. He asks it again, counsel doesn't answer it, and then he says, "You're not going to answer my question. Go ahead." And he leans back like that, and it's just, I was like, after the 10th time I saw that, I was like, what are you people doing during oral argument? But Nora and Nick, what did you see that was good or bad?
I think I echo kind of just answering the question and being straightforward. So just not dodging questions in general.
What about, did you guys, either of you see demonstratives used at oral argument with good or bad effect?
I don't recall ever seeing a demonstrative used.
Sorry about that. What did you see, Nick, or what do you think makes a good, besides answering the questions and not lying about the record, a good oral advocate?
I think two parts: going into it knowing what are potentially the weak points in your argument and just going after them right away. That's what the judges want to hear. If there's a strong point, you're wasting everyone's time by arguing that point first. unless maybe you just want to get comfortable, but then also just being very adjustable, recognizing where the judges are going with questions. And, if you quickly figure out they're interested in one point, just pivot to that point. The sort of worst parts is, I think once, and this is maybe a bit of a horror story, where someone said, "Oh, well, I'm going to get to that in a few minutes." That's no, just go right on ahead and get there now.
Did either of you see a judge ask a question that you thought or knew was designed to help the person's case, the person who was arguing, and they took it as being hostile and ran the other direction with it? Or I saw that at, where I would even write a softball question, not a softball question, but one to try to help the advocate persuade the other judges to go the way that I thought Judge Rader was going to go, and they would fight the question, and it just, not every question, I guess, is designed to hurt you, maybe what I saw, but did you guys experience that?
Yeah, that happened way more than I would have thought. I think a lot of questions in argument are softball balls or are trying to guide them in a particular way.
All right, we got.
There's a question. There's a couple of questions on this point. There's the humor one during oral argument. I would say that if the judge makes a joke, you should laugh at it, but you should not try to be humorous. I don't care how humorous you are. I've seen people try, and the opposing counsel ain't gonna laugh at you. Judges aren't gonna laugh at you, and the audience doesn't know what's going on. So at best, you got an associate next to you that'll laugh, but it's gonna fall pretty flat. So don't try to be humorous. I would say, though, that I think it's more effective at oral argument to be conversational with the court. And going to this point about first of all, I've never really seen an oral argument flip the ultimate outcome. I think it can be helpful in how they draft the opinions and in what they do. A lot of times the court is looking to kind of see how your case fits into its body of law. Are they going to screw something up? But I think in argument, if you can be kind of conversational, take the position that you're advocating for your side, but you're trying to help the judges understand the case and understand their body of law and stuff like that. And I think if you can do that, it'll kind of avoid if a softball question comes up, going off on a immediate knee-jerk reaction that you need to take an opposite or somehow an easy way to answer that. And I think if a hypothetical comes up, you're more comfortable in saying, well, yeah, I think that in that case you would want to affirm or reverse or whatever it is, but but the reason for that is because this case and that case and the law, and it goes this way, but in here the law or the policy may go another direction.
That Art's question too.
Yeah, I mean, Art asks if it's helpful to talk anything about that's not apparent or even covered in the brief, policy considerations. I would be careful about arguing anything that's not in the brief itself. And that goes for like when you get up and do your rebuttal. If you're the appellant, you don't want to start arguing things that you didn't say in your opening oral argument too. But I'd be very cautious about how you approach something that you really didn't make any kind of arguments about in your brief. Now, if they open the door and they want, a lot of times the judges don't have the full record or the full picture of what was going on below, or why you may, why didn't you argue doctrine of equivalence or something else, that was never briefed. You may be able to answer that, or why something happened that may not be very clear. That's fine. But or if a new Supreme Court case has come out, or en banc case, or presidential opinion from the Federal Circuit has come out, that may be something that you want to bring up. But I will say this, and if something new like that does come up before oral argument, I would highly encourage you to share that information with the other side. Sometimes people will file a notice with the court of a new opinion or something else that's come up, but had a lot of arguments where, you know, you find some new case comes out the week before. I don't just spring it on them at oral argument. I'll go in and I'll send an email to the other side saying, hey, there's this new case. It may come up at oral argument, or something else, so the other side knows it. Because if you start bringing up cases that you didn't put in your brief, the judges are probably going to ask, like, well, why didn't you tell the other side so they could be prepared for this, and we could talk about it at oral argument.
And I'll take that one step further, and just, if it's an important case, definitely send notice to the court. I've heard judges admonish parties for not sending notice, even if they sent it to the other side. The court wants to see it as well.
Isn't there a rule where you send a letter with supplemental authority in that? Yeah.
Yeah.
So I got a question sent to me privately. It says, were you ever, and if so, how often, were you surprised at the way a panel voted?
I've been disappointed sometimes. You know, I don't think I was necessarily surprised. I've had a few that when I was clerking there that and they really weren't patent cases. Some of them were sort of MSPB. It's another docket that I thought were really important questions, and some of the judges didn't. I convinced my judge of that fact, but the other two judges on the panel didn't. But it's the way it goes.
Anybody else? I never saw a case where it didn't come out the way we thought it would going in. I mean, did you guys experience that? I mean, obviously the opinion itself might not go exactly as far or as narrow as you wanted to, but as far as the actual result goes, I don't remember ever thinking, well, that's crazy when Chief Judge Rader came back from conference. Did you anybody experience that though?
No, sometimes I was surprised by a dissent. I think we all know that certain judges on the federal circuit dissent more than others. And every once in a while, what issue a particular judge became interested in enough to either write a concurrence or a dissent sometimes surprised us a little bit, but usually that was apparent at oral argument.
Think I've ever been like shocked or super surprised, because a lot of I felt like a lot of the cases were kind of you could tell from the briefing and the conversations you had beforehand, kind of how they would come out. So I don't think I think sometimes it was surprising in terms of the dissents or that, but in terms of the coming back from oral arguments, it didn't, don't remember being super surprised about anything.
Did any of you experience this feeling? Because I remember having this at least once, thinking, why didn't they argue? Because it would have won, and they didn't. And I always realize, well, there might be a reason, there might be something I don't see. But did you guys ever experience that and realize that you couldn't do anything about it because that wasn't your job? I see a smile on Kelly's face. Nick is smiling. Nora is smiling. Chad is looking like Chad.
I'll go. I definitely have. I mean, there are a few times I have. There's one I remember in particular that, I suppose, going back to your previous question, was one that, you know, might have flipped the case. You know, and it was just a poorly done job where they failed to make an argument that effectively preserved that for them. And I'm sure there was a reason they didn't do it. Them failing to do that lost them the case. So.
What, and this is was in one of the questions earlier, Barry, without revealing names and dates and what is it, hiding information that will protect the guilty. What's the worst thing you saw happen in oral argument where you're just like, come on, I'll go first then. I'll go. One of the judges, somebody had filed a shotgun appeal with more issues than I ever could imagine. And I don't remember which judge it was, but he or she said, you raised this issue. How did that cause your client harm? And the lawyer said it didn't. And they were the appellant. So that just ended right there. Anybody else? You guys didn't see train wrecks like I got other ones. The appellant, I'll tell one more. The panel was brutal to the appellant. I mean, just brutal. And the appellee's lawyer got up there and he said, "It's obvious that you're going to affirm." And it was not pretty.
I don't know if I've ever seen, there's kind of like do's and don'ts. I mean, like the names, there's a lot of weird names and how we pronounce them. And, the federal circuit, you had a lot of odd names. My judge being Garza is a very unusual name. And people will try to talk about, oh, Judge Garza, you said this, or Judge Lynn, you said this in this opinion. That usually doesn't end very well when you try to call out, the names of judges. It baffles me. There was one, this wasn't the federal circuit, this 11th circuit. We had a judge down here, Judge Frank Hull, who's a woman. And her given name is Frank. And I'll tell you one story. When I was there, they had I did not clerk for Judge Hull, but I clerked. She was in our court, and I had several friends that clerked with her. And they had gotten a motion in one day to redo the oral argument for the panel because some unknown woman was sitting in Judge Frank Hull's seat during oral argument. And so, that one didn't end very well either. That's probably the best like oral argument train wreck I think I've ever heard.
Yeah, I have a similar story from the 11th Circuit. We have two sets of judges with the same last name, where one is female and one is male. And I have definitely seen litigants refer to the wrong judge on the bench. It's always a bad idea to do what Chad described as the panel pandering. Those of us who've been practicing for a long time know that the Federal Circuit experimented back in 2004, 2005 with announcing the composition of a panel earlier than it does now and then had previously. There's a wide range in the circuit courts about when they tell you who your judges are going to be. I think the far end is like the DC Circuit, where they tell you way in advance, maybe at least a month in advance. And then the Federal Circuit and a few other circuits tell you an hour before your argument. And they really didn't like it when they experimented with announcing the panels a week before, because some advocates would come into court and kind of say, well, as you yourself said in case XYZ, Judge. And it was almost like a gotcha moment that the litigants were attempting to create. And what the judges were quick to point out was that the opinions are issued by the court. They're authored by certain judges, but they stand for the views of the court and the precedent of the court. And the judges do not like to have those decisions personalized. The same way they don't like us to personalize, they don't like ad hominem attacks on opposing counsel. And so at most, what I would recommend once you learn your panel composition is absolutely know how to pronounce the judges' names correctly. There's really no excuse for not knowing that. That's not inside baseball. The clerk's office is going to tell you the names. If you didn't catch the pronunciation, just ask them to repeat it. And you might, indicate or focus on a certain judge for an argument that they've been engaged in or written on a lot, just because you're prepared and sort of who the judges were on the key cases that are important to resolving your appeal. Another thing that I think can be helpful is if you are making certain arguments that are particular to procedure, like district court procedure. I mean, if you have like our newest Judge Stark on the panel, and you're making a point that has something to do with discretion that the district court judges have, for example, then just sort of a subtle, addressing of that argument to that judge can be very effective.
Our last question that, and Nick and Nora, you probably have more insight into this, or perhaps more insight into this. But if one of our in of court members wants to become a federal circuit clerk, what's the best way to achieve that goal?
It's hard to say. There isn't really a one size fits all, but I think just general things that all employers look at in a resume are important. Any type of legal employer, those experiences, grades, those types of things are important. And then I think once it gets to the interview phase, judges tend to be interested in how the clerks would fit together as a group. It is a very close-knit type of community in terms of chambers. It's a little bit different than a law firm, because a law firm tends to have a lot of members, and of course you have to work very well together, but it's a very intimate type of close-knit community. So I think the judges are interested in how the dynamics that would take place in chambers.
Yeah, the only thing I would add to that is speak to people that have clerked. A lot of folks obviously are still in contact with their judges probably. If you know them and they know you and they trust your work, they may be able to at least spotlight your application after you've applied. And certainly reaching out to as many clerks as are willing to talk to you is, I think, an okay thing to do. I've certainly had people reach out to me and give insight into it, as well as just if somehow over time you get to know them, then you can make recommendations. But the in community is big enough that I imagine you can get to know people, and that they can hopefully pass on at least a little insight into who you are as a person. Because like Nora said, that's one of the biggest factors is, are you a nice person?
I got to be a clerk, so there must be some exception somewhere. But
well, I would say that a lot of clerks, I don't know, each judge has a different practice. I know when I was there, Judge Garza would usually hire two clerks that had prior work experience, either as a clerk or in a law firm, and then he would hire one clerk usually straight out of law school. And I know that several judges sort of do the same thing. And especially for the one out of law school, he was always looking to professors or people that they clerked for Wilmer Hale, or they did a summer internship with Wilmer Hale, and his buddy at Wilmer Hale recommended them. So I mean, there's always sort of feeders like that. But I mean, I can tell you, when I did it, I was at the University of Georgia. I was lucky to get I kind of applied to all of them. But I know I reached out to my admissions office, some of the professors at University of Georgia, and I was like, do we have any alumni that have ever gone up to the federal circuit? And they said, oh yeah, there's this girl, Kelly Casey, who Kelly Mullally now, who did. And so here's her phone number. And I gave her a call and about what to do. And she gave me advice. And then when I actually got an interview, she was like, oh, here's what I know about the judges and everything else. And, when I got up there, I've kind of used some of that inside information. So, anything you can do to kind of reach out to people either from your law school or law firm or in this inn. I mean, I think we have a lot of former federal circuit clerks in this inn, myself, Kelly, David, of course, Tim Holbrook was a federal circuit clerk, and I know he sent several students up to be federal circuit law clerks. I think we have an inn member that's going up to clerk for Judge Toronto maybe next year. We have, from Atlanta, we have a pretty good reputation of sending good people up there that fit in well and are pretty knowledgeable. I haven't heard of any clerks that have done poorly that the judges don't like. And I even though I've been gone for a long time, I still keep in touch with a lot of the judges up there, even some of the newer ones that came on after my time. And so reach out to the people to get some advice. And if you are somebody that has some prior work experience, don't think you can't go up there and be a law clerk. I think most of the judges are kind of looking for people who have been out for a few years or have a clerkship background.
I'll end with one last little story where I was, what, 52, I guess, when I clerked. And so there are areas that clerks only are allowed in. And the CSOs would try to kick me out of there because they'd see me and they'd think I was not a clerk because I was so old. On the other hand, I would walk into rooms sometimes and everybody would get quiet because I was old and they thought I was a judge either in the Veterans Court or something else. So I didn't fit in anywhere, I guess is my point. But I would say, just to recap that, it was the best job I ever had. It changed how I looked at the law, even though I'd been practicing for whatever, 20 years. I think it made me a better lawyer, made lifelong friends out of a number of judges and fellow clerks. And if you are interested, I can do what I can. I'm sure I'm about to flood Nora and Nick's email. They would help you in any way that they can as well. But I want to thank everybody for their time, but particularly Nora and Nick for visiting with us in the inn. I really appreciate your time and your insight. And if we can ever return any sort of favor, please do let us know. And with that, I hope I can turn it back over to the hosts because I don't know what to do now. I think Jason or Rich.
So Chatham is going to be sending folks into breakout rooms.